Your Honor. Good morning, everyone. Today we will present a role play regarding a tort of negligence. The case concerns Miss Lisa, a professional pianist who suffered injuries during renovation works at Elite Residence. The court must determine whether Probate General was negligent and whether Ms. Lisa is entitled to compensation.
Before that, let me introduce you to our group members.
This is Elite Residence, a luxury apartment building that is currently under renovation. Elite Residence hired Probate General to carry out the renovation works.
Let's put design. So, for the duration of the renovation work, Probate accept no liability for any loss of or damage to property, death or injury to any person howsoever caused.
Hey, can you pass me the hammer?
Yeah, sure. Meanwhile, Miss Lisa walking near the construction site and the hammer hit her arms.
Oh my God!
The residents at the scene witnessed the incident and immediately called an ambulance.
Somebody call an ambulance! I'm sorry, Miss Lisa. Unfortunately, your arm is broken. Oh no, I'm a pianist. I may not be able to play piano anymore.
Miss Lisa wishes to file a lawsuit against Probate General and is seeking legal representation.
Assalamualaikum, Miss.
Waalaikumsalam. Is there anything I can help?
I want to claim compensation, but I don't know whether I should sue Probate or Elite Resident.
Let's see whether negligence can be proven.
But they put up a notice that they are not responsible.
That notice does not automatically protect Probate. You never agreed to it, and a company cannot simply avoid liability for negligence by putting up a warning sign.
But can I sue Elite Resident too?
Usually, Probate as the contractor is responsible for its own negligence. Any resident would only be liable if they were also negligent. For example, by hiring an incompetent contractor or interfering with the work. There is no evidence of that in this case. Finally, you suffer actual damage. You have a broken arm, medical expenses, pain and suffering, and because you're a pianist, you may lose your future income.
Oh no, that has affect my career.
After gathering sufficient evidence to support Miss Lisa's claim, her lawyer filed a lawsuit against Probate General. A few days later, both parties appeared in court for the hearing.
Counsels, please present your arguments.
Your Honor, on the morning of 20 September 2020, I was walking beside the apartment building. At that time, renovation work was being carried out by Probate General. Suddenly, the scaffolding collapsed. Several tools fell from above and a large hammer struck my arm. I was immediately taken to the hospital and the doctor confirmed that my arm was broken. I work as a pianist. Playing the piano is my profession and my source of income. Because of the injury, I cannot perform properly and I may lose my career. I have suffered pain, emotional stress, medical expenses, and loss of income.
Your Honor, the defendant owes a duty of care to members of the public. Construction work is dangerous and contractor must ensure that their equipment and scaffolding are safe. Ms. Lisa was walking lawfully outside the building. She was clearly a perceivable victim because pedestrians regularly passed through the area. Secondly, there was a breach of duty. The scaffolding collapsed during the renovation work. A reasonable contractor will inspect the platform and ensure that proper safety measures were taken. Thirdly, the negligence directly caused Ms. Lisa injuries. Without the collapse of the scaffolding, the hammer would not have struck her arm. Finally, Ms. Lisa suffered actual damage, including physical injury, financial loss, and emotional distress. Therefore, all elements of negligence have been established.
Your Honor, the defendant denies liability. Before commencing the renovation works, Probuild displayed a notice stating that the company would not be liable for injury or damage. The notice was clearly placed on the exterior wall.
Your Honor, the notice cannot exclude liability for negligence. Ms. Lisa never agreed to the notice and there was no contract between her and Probuild. She was simply a member of the public working near the building. The company has a responsibility to protect people from foreseeable harm. The collapse of the scaffolding itself proved that reasonable care was not taken. Construction company must ensure public safety. Therefore, the defendant cannot escape liability merely by picking a note.
Your Honor, we respectfully request the court to consider all circumstances. The company did not intentionally cause the accident. The incident was unexpected. If liability exists, other parties such as elite residents may also share responsibility.
After considering the evidence, the court finds that Probuild owed a duty of care to Ms. Lisa. The collapse of scaffolding demonstrates a breach of that duty. The injury suffered by Ms. Lisa was directly caused by the defendant negligence. Ms. Lisa suffered physical injury, medical expenses, pain and suffering, and loss of income as unpaid pianist. The warning notice cannot automatically exclude liability against members of the public. Therefore, Ms. Lisa has a strong claim in negligence against Probuild Sdn Bhd. She may claim compensation for her injuries and financial losses. This case shows the importance of safety and professional responsibility in construction works. Court adjourned.